Well, good morning, everyone. I'm Bill Thornton with the Georgia Municipal Association, and we want to welcome all of you to this morning's webinar, Tools for Code Enforcement. It's being brought to you by the Georgia Initiative for Community Housing. Once again, we're very pleased and really honored to have Brandon Bowen making the presentation for us this morning. Brandon has done this for GIC on a number of occasions and always does a great job, and we get great feedback. For those who don't know Brandon, he's an attorney in Cartersville with the firm of Jenkins and Bowen. He has agreed to do this really for a second time. We were offering the session earlier in September, had some technical issues. Those have been resolved, so we're going to do it again, and I know you're going to find it to be very informative. If you have questions during the webinar, please type them in. You'll see a little panel on your right-hand side where you can type your question. We'll be monitoring those questions and interrupting Brandon as we have the opportunity to make sure he gets a chance to respond to your questions. So with that, Brandon, I'm going to turn it over to you. And again, thanks so much for joining us this morning.
Thank you, Bill. And good morning, everybody out there. As Bill told you, I am a lawyer in Cartersville, Georgia. I've been practicing in land use and zoning and local government law for 12 or 13 years or so. And I have the opportunity to do this presentation or similar presentations for GMA and GIC and ACCG and various other institutions throughout the state. You'll see as you look at your screen, it is dated September 3rd, 2014. We initially started there and had some technical difficulties, so I'm redoing it. But I will tell you this, for those of you who were not able to be there then, or actually who were available to attend on September 3rd, I did update the seminar paper since that date. I did not change the date, but there actually are 7 new slides near the beginning, so maybe you'll get a little more out of it this time. I do want to encourage you to ask any questions. This format is not necessarily the best for asking questions, or at least not like a live presentation, but I normally get some pretty good questions, and I would encourage you to do that if you've got one. I always encourage people to remember, though, that before you act on any of the suggestions I have here, do run it by your city attorney. Make sure that what you want to do is going to work in your city. So that said, I'm going to jump right into it. All right, I'm going to talk today about a number of the tools that are available to local governments in Georgia for code enforcement. There are a number of tools out there, and just like a toolbox has tools to fit different situations, each tool is better or worse for different applications. So I'll talk about the various things out there, and we can talk about which tools work better for different situations. So I'll talk about the state minimum standard codes, which are overseen by the DCA. I'll also talk about the permissive codes. I'll talk about some useful ordinance provisions that people, or that we often see put in zoning ordinances or things of that nature, particularly if your jurisdiction does not wish to adopt the permissive codes. I'm going to talk about the public nuisance law and also the unfit property law, which right now I'm doing a lot of unfit property actions around the state. But that has been a big issue, particularly in the wake of the recession. So I'll talk about that in great detail. And that is really one area where I see people can update their codes and make the code more useful than maybe it is right now. Okay, there are a number of state minimum standard codes, and these codes apply throughout the state of Georgia, whether or not local governments adopt them. They, by statute, they apply in every jurisdiction. These are codes that are prepared by the International Code Committee. You see the ICC references there generally. They are reviewed by DCA, and in some cases DCA has prepared Georgia-specific amendments, and those codes with the Georgia amendments approved by the DCA are adopted as a matter of law and applicable in every jurisdiction. So sometimes I'll see local governments have codes that adopt this code or that code. You don't have to adopt these codes. The state legislature has already done it for you. What local governments do need to do is adopt ordinances or building codes that provide the administrative process that they're going to follow in enforcing those minimum standard codes. And this is the area that I have really added on to since the last time I put this presentation on. First, I'll say both DCA and I believe GMA have model building codes that you can look at and take and tailor to fit your jurisdiction. Your building code needs to cover a number of issues. The first is who's going to be the office or the officer responsible for enforcing your building code. Now, if you have you may have an employed building inspector or a building building inspecting office that will review all building permit applications, review the building, do the inspections, and you may have one office that does that, and so you may have the whoever is the director of that office that is named as the enforcer. If you're in a smaller jurisdiction, what I see from time to time is we'll have a company on contract to do our building inspecting work as building permits come in. And so this is a outside company that may be appointed to serve as building inspector, and they're not on the clock. They're not charging the city except when a building permit application comes in, and then they'll review the permit, advise the city clerk as to whether or not the permit should be issued, and then schedule the various inspections, and ultimately maybe the certificate of occupancy. What you can also do, and in fact, if a city fails to properly provide for inspections, then in some cases under the law, a private property owner can hire a private inspector to do all of the inspections that would be required under the ordinance and just turn them in. So what you might consider doing if you have a low budget and you don't wish to contract directly with a building inspector, you could hire applicants to file inspections from a certified building inspector or a licensed building inspector, and that may solve the problem. So there are a variety of ways that a city could tailor their building office, their building inspections office to suit their needs and their budget. But this ought to be laid out in the procedural or the administrative building code. Now, what is the process? Generally, under your building code, it's going to begin with a building permit. So this is where someone's going to come in and file an application saying what they wish to build, and you have someone who you've appointed to review that and determine if it's appropriate for them to build that, and then issue that building permit. I prefer to see those issued administratively. I have seen jurisdictions that have, particularly small jurisdictions, that have the council issue them. I don't really advise that. I think you're better off having someone who is either employed to just do building work or an outside person who determines whether or not the building ought to be built. And that the question comes down to, is we look at the zoning classification. Does the lot meet the dimensional requirements under that zoning ordinance or whatever the land use code is? And is what they want to build, does that comply with that building code and the various land use codes? So issued as a matter of right generally, unless there's some ordinance that requires special approval. So what we might see is, say you're talking about an asphalt plant. Well, that may be a special use under your zoning ordinance. So in that case, they wouldn't get a building permit. They'd have to apply for a special use. But for most things, for instance, the single-family residential house in your R1 zoning classification, they're going to come in and show that what they're zoned, that the lot meets the dimensional requirements, that the house is going to meet the requirements in the ordinance, and if it does all that, then the building permit is going to be issued. Your building code ought to contain in it a list of the things that you're going to require that applicant to file. So I've seen these as basic as a one-page document that says, what are you zoned, what do you want to build, and, and that's it. I've seen them extremely complicated. You have to decide what is appropriate for your jurisdiction. The common things that you would see, a site plan that's going to show what is the dimensions of the lot, what are the setbacks, is the building going to comply with all of those things. You may require elevations. An elevation, of course, is a rendering of the building that's going to be put in there. Particularly if you have architectural codes, things of that nature, you might want something like that so that the permit reviewer can determine if that's going to comply with your code. You might have it show where the septic or sewer is going to be, the other utilities. If you have an ordinance that requires particular landscaping or a tree protection ordinance or something like that, you may require a landscape plan. So you would look at what all requirements your various ordinances have, and then you'll require the applicant to file those with their building permit application so that you can look at what they plan to do and make sure that's going to comply with the various codes. Your ordinance your building code ought to talk about when your inspections are going to occur. So for instance, the building permit gets issued, then you're probably going to want your building inspector to do a number of inspections throughout the process. Because obviously, once the house is done, if we're talking about a house, you can't go in then and tell whether or not they comply with the electrical matters or the plumbing issues. It's too late because the sheetrock's in and whatnot. So what you have is a process that requires inspections throughout the building process to make sure that everything is done properly, as each stage of the building construction is completed. What we commonly see is that the final inspection that determines that the house or the building has been properly built results in a certificate of occupancy or a certificate of occupation. And it is at that time the ordinance provides that the property owner can then go into either living in the house or get the final utility hookups, those types of things. One thing I like to see added here, and I've been doing lately, is if down the road, if the property is not maintained in compliance, it's good if your ordinance provides that the building inspector can revoke that CO. So for instance, if somebody is not maintaining, let's say they're not maintaining their septic system, so to the extent that the house becomes unfit, well, then the building inspector could revoke the certificate of occupancy and require the people living in the house to not live there until the problem gets resolved. I've also seen situations where we have in the ordinance that the building inspector has the authority to direct utilities to stop service, particularly water. That's one way to resolve problems with people not maintaining their property. So that is there are a couple things that you can do to give your local government tools to deal with unfit property situations right through the certificate of occupancy and to make sure people maintain their properties in compliance with the various building codes. This administrative building code ought to cover fees. How much are you going to charge for your building permit or for the various inspections? Obviously, that's going to be determined on what your jurisdiction does, how detailed your jurisdiction is in the permit review process. The thing to keep in mind is that the law requires that regulatory fees, such as those for building permits, be reasonably tailored to defray or to pay for the cost of actually providing the service. Now, that doesn't mean they have to be precisely the cost that the city incurs, but they don't need to be strictly a means of generating revenue. They need to be reasonable in light of how much it costs the city to provide that service. So you need to look at how much time your staff is going to be putting into the review process. If you're using an independent contractor to provide the service, how much are they going to charge the city to do the various inspections? And just make sure the fees will cover the city's costs without being out of line with what the city's costs are going to be. Lastly, this is very important, your administrative building code needs to have an appeal process. And this is so if anyone is building well, for instance, let's say your building inspector goes out to do an inspection and determines that the property is not being built properly or not being built in compliance with the codes. Your ordinance may provide that that building inspector has the authority to issue a stop work order that tells him, don't work on any future aspects of this building until you fix what you've done before. If the property owner or the builder disagrees with that stop work order, he needs to have the ability to appeal it. You may have a board of appeals that it goes to. Commonly, these ordinances have a construction board of appeals, which would be some folks in your community who have experience in development and building. So maybe if you've got some architects, engineers, builders, you might appoint them to sit on this construction board of appeals, and they'll hear this, and they'll decide if the building inspector made a good decision or not. You've got to have an appeal process in your administrative ordinance. And I did not stress this in one of the earlier slides, but I think it is wise to have in there the provision to issue a stop work order so that your building inspector has the authority to do that and get compliance before construction continues under that building permit. Another thing that you may have in that ordinance is you may put a time limit on a building permit. You may tell someone, all right, we're going to issue your building permit, but you have to have the construction substantially completed within 1 year. Why would you want to do that? Well, what if they get this building permit and they sit on it for, say, 5 years, and in that time period, the codes change or your ordinances change? Well, now we've got a problem. Is the building that you have previously approved, does it comply with these new codes, or should they be required to fix the problem? Putting a time limit on that building permit prevents that problem. It tells them if they don't get the work done in a reasonable fashion, they're going to have to start over, and they're not going to keep vested rights from that building that was permitted but not actually constructed. I'll take a little tangent here. What happens if your building inspector issues a permit that is issued in error? You know, let's say he issues a permit to build a sign in an area where your ordinances say a billboard can't be located. Well, that is exactly what happened in the case Corey Outdoor Advertising versus City of Atlanta. There, Corey Advertising applied for a building permit for a sign, an outdoor for an outdoor advertising sign. The permit was granted by the building inspector, and they put the sign up, and about the time that happened, the folks on the city's Historic Preservation Commission noticed that this sign had been built in the historic district. Well, the city's ordinances said billboards could not be installed in the historic district.
Brandon, I have we've gotten a question. I thought if I could interrupt you briefly.
Okay.
The question is, if there's no appeal board provided for in a jurisdiction, is it legal for the building official to act as the appeal person?
Okay. So the question is, if there is no appeal board, does the building inspector act as the appeal officer? Probably not. That's probably not a good strategy. And the reason is, okay, let's say I'm the building inspector and I issue a stop work order. I deny a building permit and someone wishes to appeal. Well, I think we've got a problem if I'm the one deciding whether or not I made a good decision. And I think that procedure would be susceptible to a challenge in court. So I think the better process would be to look at, either establish a construction board of appeals or look to what other boards your jurisdiction has. For instance, you could always just send the appeal to the city council if you don't want to create a new board. Or you might have a planning commission that could do it. You might have a board of appeals for zoning issues that could do it. There are a variety of options, but you do need to have somebody other than that building inspector who's going to make that decision. Going back to the Corey outdoor advertising situation, the take-home message from that case ended up in court when the city of Atlanta tried to revoke Corey outdoor advertising's permit for a sign and make the sign come down. And the court there held, the Georgia Supreme Court, held that property owners, developers, take no rights from permits that are issued in error. And the permit there should not have been issued because the sign was not legal in that jurisdiction. The court said Corey should have known that its development was not appropriate for that jurisdiction. Now, that's a hard rule. That means Corey had to take down its sign. There's another case in DeKalb County, Gray versus DeKalb County, that has a similar rule where a house was built inside of a setback. Permit was issued, house built, and then later they found that the house was built inside the setbacks. The house had to be removed because of that. It may seem as a very harsh rule, but the courts say we're not going to frustrate the government's authority to regulate based on an error made by a administrative official. So that's an important rule. And again, a situation where an appeal board would, having that there is a way to remedy those errors. Okay, so we've talked about the state minimum standard codes. I want to talk now about the permissive codes. These are codes which do not apply throughout the state unless they are expressly adopted by the local government. One is the International Existing Building Code, and the other is the Property Maintenance Code. I'll talk just briefly about the Existing Building Code. If you are in a jurisdiction that has houses that are commonly, older than the model building codes are, or the standard building codes, houses that were built before there was a standardized code procedure, you probably face a situation of people coming in saying, I want to buy this property, I want to buy this old house, I want to modernize it, and that is a challenge. How do we reconstruct or add on to, update the old building in a way that brings it into compliance with the code as much as is feasible? The International Existing Building Code, that's its focus. So if you're one of those jurisdictions that has a lot of older homes, older buildings, you may want to look at that and adopting it. The International Property Maintenance Code, I'm going to spend more time talking about it. It is very useful in dealing with problem structures, unfit structures, properties that have not been maintained properly. Code enforcement officers love it, the International Property Maintenance Code, and that is because it has a number of very detailed provisions that allow the code enforcement officer to go to the property owner and say, this is precisely what's wrong with your property, and this is where you're in violation, and this is what you need to fix. So they look at it as a great tool from an enforcement standpoint to get compliance. Now, on the downside, I have seen a lot of jurisdictions that view this property maintenance code as virtually socialist, as being too doctrinarian, too authoritarian on the part of the government. So every local government has to look at it separately and decide whether or not it works for them. I'm going to flip through some of these various provisions just to show you what I'm talking about here. So here you can see these are provisions from the Property Maintenance Code that talk about maintaining property, structural members free from deterioration, how windows and door frames ought to be maintained, how stairways and landings and balconies ought to be maintained. Rodent harbors. This always is a problem where people keep junk and debris around their property in such a way that it becomes a good home for rodents. And so it puts the duty on the property owner to perform an extermination and then fix the property in a way that it won't happen again. So this one deals with graffiti. And interestingly, it makes it a violation to commit graffiti, but it also puts the duty on the property owner to fix the graffiti if their property is damaged like that. These are other sections that deal with maintaining the exterior of the property, free of junk and trash and debris in a sanitary fashion. So these are tools that your jurisdiction could use if you've got people not maintaining their property. You've got this code, the permissive code. If you have adopted, then your officer could go and show them this, and if they did not comply, he could issue a citation, require them to go to municipal court for violating the property maintenance code. Yeah, this deals with swimming pools, requires fencing for swimming pools, which a lot of times is, a lot of times people don't like that, but obviously it has a good purpose of protecting, particularly protecting children from wandering into pools that are not properly enclosed. Okay, so those are a number of provisions from the Property Maintenance Code. I think you can see why it is popular with code enforcement officers, but why it also may be divisive to adopt it, and why a lot of jurisdictions look at it as being too more than they want to put into their code. If you're one of those jurisdictions that says, well, we like some of the provisions, but we don't want so much of that, I think the thing to do is to look at the issues that you're most particularly concerned about, and then just put them in some other ordinance. For instance, I commonly put them in a zoning ordinance. You can put them in your nuisance code as well, but provisions that talk about things like how people maintain their property, junk, trash, and debris, junk cars, I know in a lot of jurisdictions that's a big issue, where people leave their cars, or they've got that car that they're going to get around to getting it fixed, and it's been sitting there for 20 years. Or we may see where situations where people say they're working on it, but it's been sitting there for a long time. Maybe they're going to sell it, but nevertheless, you've got a car that could not be run on the road, doesn't have any valid registration, license tag, things of that nature. I think it's very good to have a good definition of what a junk car is to cover, whether or not it's legally operable on the roads of the state. One of the provisions that I like to put in the zoning ordinance is one that says you can't have junk cars except you can have one stored on the exterior of your property for purposes of repair for no more than 6 months. So if you actually have a car that you acquired and you want to fix it up, as a lot of people enjoy doing as a hobby, you can have one, but you're limited to one, and there's a time period. Now, of course, we also provide that they can keep it longer if they put it inside a garage, so it's not a public problem. But we do that strict by making detailed ordinance provisions that explain that. Another issue that comes up a lot is storage containers. We've seen these pods, and it used to be that people would get those just to load up and go store them somewhere else, but now people get these storage containers and just put them on their yard and keep them there permanently. That's an issue you can address through these, standalone provisions. One thing I do like to put in there is I like to state in there, well, let's say the way you're going to enforce this is your code enforcement officer is going to issue a citation. Generally, that's how you enforce this. So it's good to have minimum fines stated in there, because if your municipal court may not consider these violations to be all that important. He may be dealing with bigger issues on a regular basis, that judge. So if you put minimum fines in there, say $150 per day for junk and debris, well, that creates a situation where he is essentially obligated to issue that kind of fine if he finds a violation has occurred, and that can be useful in getting the problem resolved. Okay, I like to spend some time talking about code enforcement staff. In a lot of jurisdictions, the code enforcement officer is going to be a civilian, or it may even be someone who wears another hat. In a smaller jurisdiction, it may be code enforcement officer may be part-time, or it may be the building inspector or the zoning administrator. There's no set way it has to be done. In other jurisdictions, it may be your police officers, or your police office may have a detail or one group of officers who focus on code enforcement matters. I've seen it done in a number of different ways in different jurisdictions, and it's up to you. And there's no requirement that a code enforcement officer be post-certified, be licensed to carry a gun, or anything of that nature. Civilian code enforcement officers will often tell you that they are more effective than police officers because they're not so intimidating to people. So, for instance, they can go up, they're not wearing a uniform other than maybe a collared shirt with the city logo on it. They're not carrying a gun. They go in and they deal with the person who's there in a non-confrontational manner and try to negotiate compliance, and if they can't, then they issue a citation and go to the municipal court and deal with it there. Other jurisdictions prefer to have their police staff handle this, and there are good reasons for that too. One of the things I have found in my career is that the junk cars and debris and things like that, those violations oftentimes go hand in hand with other criminal violations. Drug violations, child abuse situations where people are living in houses that are not appropriate, things of that nature. If you've got the police officer who's trained to deal with those criminal matters, he may be in a better situation to deal with those things when he comes into a situation that maybe he goes there for trash and debris, but finds these other criminal problems when he gets there. Now, that issue can be remedied by having a good relationship between your civilian code enforcement staff and your police department. I certainly encourage that for any jurisdiction that does have civilian police officers, so that those civilian code enforcement officers have the ability to get backup immediately from the police department.
Brendan, we've gotten another question. If you don't mind, I'd like to pose it to you. Would the grandfather clause be an issue if you adopt an ordinance and the car or sign was there before the ordinance was adopted?
Okay, the question is, if you adopt an ordinance and you have I presume that means a junk car or a sign in place, is it grandfathered? That is a tricky question to answer. If you're talking about a sign, generally, if you did not have a sign ordinance before, so someone had a sign in place and it was legal, it's going to be legal non-conforming use when you adopt a sign ordinance. And normally those sign ordinances will provide that a use can either stay if it's a legal non-conforming use but not be modified, or it may provide that it can stay for a certain period of time. If you adopt an ordinance that says no signs that don't comply with this ordinance may remain, then you are probably going to face a challenge that you have taken the value of that sign. And, if you're talking about a billboard, that could be a lot of money. So a lot of times, those non-conforming uses will be protected. Now, on the other hand, if you're talking about a junk car, that's not necessarily a use like a billboard sign. That's just a car that's been parked there. And you're not affecting the use of the property in a legal sense. You are taking the use of the property by saying you can't keep a junk car on it. You're just regulating the use, which is not taken. So long as you leave reasonable value to property, you can regulate its use or adopt regulations that would apply to existing properties. For instance, a great example of this is the City of Atlanta parking case. In the lead up to the 1996 Olympics, Atlanta adopted an ordinance that required people who owned parking lots, these commercial parking lots, to plant trees in there to make it more aesthetically pleasing for all the people who were coming from around the world to visit Atlanta. Of course, planting trees in the parking lot meant that parking spaces had to go. So it undoubtedly affected the amount of money that the property owners could make from their parking lots. And they sued. And the Georgia Supreme Court said, look, this is not a taking. Just because you have an existing parking lot and the city has come back and said you have to plant some trees in it, that's not a taking. You haven't taken the value of that property. The city was just regulating the use of it, and so long as it's reasonable and rational, the city can do that. So likewise, I think even if you have junk cars throughout your community, you can adopt a regulation that would require people to not keep junk cars in the community, subject to certain provisions. And once you do that, you could go about enforcing it. Now, let's look at it a different way. What if you've got somebody who has a junkyard, and it's their business operation, and you don't have any kind of zoning restrictions? Now you adopt one that says no junkyards in this district. Is that going to be a taking? You're probably going to have to protect that person's or allow that person to continue operating their junkyard because they have an established use at a time that it was legal. On the other hand, you could go back and say, well, non-conforming junkyards can stay in place. However, we're going to regulate their use by requiring them to install vegetative buffers 10 feet wide surrounding the property. Courts have said you can do that to an existing use. You can regulate its use without taking it all together. So that was a tricky question to ask, and I hope I've answered it. Turning back to code enforcement staff, of course, your code enforcement staff, they're going to be able to issue citations to your municipal court. And I believe everybody who's on the phone with us today represents a city. If you were in a county, we wouldn't be talking about your municipal court. We'd be talking about your magistrate court, which has very similar jurisdiction as the municipal court, but the magistrate court has jurisdiction in the unincorporated portion of the county. Municipal court has jurisdiction in the city. One thing that I really encourage code enforcement officers to do is to develop a system to track complaints for each property and to track when citations are issued, what remedies are issued, and keep that over time. That is very helpful for a number of reasons. One, for the staff, it really helps justify their budget because it shows what they're doing. What is the reward that is being received for the city's budget expenditures. For the governing authority, it's very useful for them to be able to see where their citations are coming up and what's being done about it. Is it effective enforcement? When you're in court, having this system to track complaints is very useful too, because one of the biggest defenses that we'll see a defendant raise is, well, they are enforcing this ordinance against me, but they're not enforcing it against anybody else. Well, the way that you defeat that selective enforcement claim is to show, no, we've got citations for this same problem all over the city, and we enforce it even-handedly. Also, one of the things I see a lot in court is your code enforcement officer has done everything they can before they issue that citation. They talk to people, they write letters, they hang door hangers that show what the violation is, they make calls, they can't get compliance, so they finally issue a citation. Well, the last thing you want to happen at that point is for the judge to say, all right, property owner, I'm going to give you 90 days to get your junk cars moved, and start that whole process of trying to negotiate compliance again through the court. You want to be able to show your municipal court, Judge, we have bent over backwards to get compliance without taking up your time. We can't do it. We want a citation issue. So you want a system to show that, and this also ties back into having those minimum fines so that the judge feels compelled to issue the citation and to issue a fine. We got into a situation in one jurisdiction a while back where the judge he would find guilt, but he'd suspend the sentence and order us to go back out there, the code enforcement officer to go back out in 60 days and then put it back on the calendar. Well, after a while, our staff did not have time to deal with new violations because they were spending all their time doing rechecks on old violations, and we still didn't have any citations or any fines imposed, and it didn't get compliance because people knew, hey, the worst thing that's going to happen if they find me guilty is he's going to give me 60 days. Clean it up. So it really, we just felt like it wasn't effective, and we had to take some pretty aggressive actions to get that problem fixed, which we were able to do. But having a system to track complaints and show the judge just how much you've tried to work with this person before a citation was issued can be very helpful in getting enforcement.
Brandon, a few questions have come in, if I could interrupt you.
Sure.
The first one is really for all of the folks online. We've gotten a question wanting to know if any of the agencies represented recommend a particular tracking system software program. And I would say if you have something that you're pleased with and you'd like others to know about, you can email me, Bill Thornton at GMA, that's B Thornton, THORNTON, at gmanet.com, and we will accumulate those responses and make sure we send those out. But a couple of questions for you, Brandon, have come in. The first one is, can a city resident be charged under a county ordinance and taken to magistrate court? And then I'll let you respond to that, and then I've got a follow-up question from someone else.
Okay. Yes. Can a person be charged under a county ordinance if they live in the city and be taken to magistrate court? Generally, the answer to that is no. The county ordinance is not going to have any authority over city residents in the city. Now, of course, if a city resident owns property in the county and they have a violation out in the county, then yes, they could go to magistrate court. But if you're inside the city limits, you've got to comply with your city ordinances, not your county ordinances.
Okay. The second question is, can a code officer issue a citation on property maintenance structure without being certified in property maintenance?
Can a code enforcement officer issue a citation if they're not certified in property maintenance? And by certified in property maintenance, I presume you mean a building inspector? Well, yes, they can issue the citation. However, if someone pleads not guilty to that citation, they've got to be able to prove that the citation or the violation exists. So you have to look at what the violation is and whether or not that person is competent to prove it. And that depends on the situation. For instance, if the violation is that I've got tall grass, it doesn't take any kind of special training to know that vegetation is greater than what is permitted by the ordinance. On the other hand, if you're talking about, that this structure does not comply with aspects of the building code, you're going to need somebody who is licensed to talk about the building code, so a building inspector or something of that nature. So, yes, they can issue the citation, but you have to remember they have to be able to prove it, and that's that can be an issue. For instance, I have had in unfit housing context, I've had situations where, I'm a lawyer and a history major. I don't know anything about building codes or how to build a house, but I can look at a property and say it's unfit if it's a burnt-out structure. I can do that. However, if what we're talking about is, well, we've got leaning floors and we've got structural members that may not be properly maintained or the right size, I don't have the knowledge to be able to explain that. So we need somebody who is certified as a building inspector to talk about those types of violations. Bill, were there any other questions?
Actually, there is another question that's coming in. Referring to ICC certification as required by state law, is that what you're referring to? And it says property maintenance inspector certification available.
Yes, I believe so. If you're licensed as a building inspector, that's. If I'm going to talk about violations of the building code that get to technical violations, I want somebody who is licensed by the state to inspect homes to be able to give that testimony.
Okay, thank you.
And in fact, I've seen situations where we have a building inspector who is not the code enforcement officer, and we have a court code enforcement officer, and they work together. Code enforcement officer issues the citation, but when we go to court, I need to have both of those people there to testify. One can talk about the issuance of the citation, and the other talks about the technical violations.
Thanks.
All right. Talk a little bit about municipal court. Again, the municipal court is going to be dealing with citations and violations that occur within the city limits. Great thing about the municipal court is you can generally get on the calendar very quickly. They're going to be locally responsive. Generally, the municipal judge is appointed by the city council. It's not going to be expensive to go to municipal court. You may or may not use a city solicitor, depending on the situation. Some jurisdictions do and some don't. But generally it's a very cost-effective way to get a citation issued and addressed. Now, there are some big caveats or exceptions to this next statement, which I'll talk about. But generally, a municipal court judge only has jurisdiction to issue fines. They generally cannot order someone to fix a problem. But there are some big exceptions to that I'll talk about. slide here. Yeah, jurisdiction is normally the city limits. Normally, we do not have jury trials on citations except where it's a state law violation. So a state law violation would be like if someone gets a DUI in your city limits, that will initially go to your municipal court, but they can demand a jury trial. If they go to a municipal court based on a junk car violation, that probably is not going to go to a jury. Sometimes we have situations that are really severe, where we just feel like we need to ratchet up enforcement a notch. I'll give you an example. There's a city in middle Georgia that has had someone operating an illegal junkyard for 15 years, and they have been trying repeatedly over that period to get relief to the municipal court, and they've just never been able to get the relief they wanted. So they hired me, and I filed an action in the Superior Court, which is the main trial court, to get an injunction that would regulate how or control this junkyard and put this junkyard out of business. The Superior Court can be very effective on serious enforcement matters. They can handle any kind of violation in the city or the county. And the great thing about the Superior Court is that they're going to be able to issue injunctive relief. Injunctive relief is an order saying you must do this or you must do that, as opposed to just a fine. You can still get the fines, but you can get greater relief in that there's actually an order that something be done. And this is very important, the Superior Court has the contempt power, criminal and civil contempt power. What that means, and what I've seen oftenly, is, we'll go to court with someone in the Superior Court who we've not been able to get compliance with the municipal court, and we'll get an order telling them, clean up all these junk cars within 30 days. And he's ordered by the judge to do that. Well, that 31st day comes, we send the code enforcement officer out there, junk cars are still there, I put it on the calendar, the judge's calendar, for a contempt hearing. And when we show up, unless that property owner has a really good excuse, the judge is probably going to find them in contempt. And what he may do, he may, and I've seen this happen, put them in jail until the property is cleaned up. And all of a sudden, their friends and neighbors and family, they're out there cleaning the property up for them to get them out of jail. May issue additional fines. Judges get very upset when people don't comply with their orders to do something. So that can be an effective remedy. And really, what I have found, nine times out of 10, if a case is bad enough to warrant going to Superior Court, when we file that, we'll file it with a hearing date, and on that date, the property owner is waiting outside the courthouse, ready to sign anything I have to keep from going inside that courthouse. So it can be very effective in getting relief when all else fails. Okay, there are two big exceptions to that rule I told you about, where the municipal court cannot order someone to do things. The first is the statute providing for the abatement of a public nuisance. Now, a nuisance is anything that causes hurt, inconvenience, or damage to another. And there are public and private nuisances. A public nuisance is a nuisance that affects the public as a whole, or the community as a whole. And a private nuisance is one that affects a very limited class of people. So if you're talking about private nuisances, maybe you're talking about, maybe somebody has reconstructed their property in such a fashion that water is pushed off to their neighbor. It's just hitting just their neighbor. That's a private nuisance. That's a dispute between the two of them. The local government probably should not get involved in that unless there's a violation of your ENS, soil erosion and sedimentation ordinance, or something of that nature. Just as to the nuisance issue, That's a civil matter between those two folks. Let's say, on the other hand, you've got somebody who has put in an asphalt plant and it's blowing smoke all over the city. Well, that's affecting the community as a whole. That's a public nuisance. And in that situation, the city attorney or the city solicitor can file a public nuisance abatement action. Now, your ordinance, you may have a public nuisance ordinance, or excuse me, just a nuisance ordinance, that lists out things that are nuisances. Commonly what we see in there is barking dogs. But you can, anything that you have that you feel like is a nuisance in your community, you can list in that ordinance, and then your code enforcement officer or your city solicitor can file a nuisance abatement action and ask your municipal judge, your municipal court, to order an abatement. Now, abatement simply means the judge has the authority to order someone to fix it. Importantly, something can be a nuisance even if it's legal. So suppose you have that, we go back to that asphalt plant example. Suppose they have a permit from the EPD or the EPA to issue all this smoke, and it's legal as far as the EPD is concerned. Well, it can still be a nuisance to your community, and so you can still file a public nuisance action based on that. All right, so you would file this public nuisance action, or your city attorney or city solicitor would file it, and your municipal judge has the jurisdiction to actually order someone to fix it. It's one of the few exceptions to the rule that the municipal judge does not have injunctive power. The other issue or other situation where the municipal court has the ability to order someone to fix a problem is under the Unfit property statute. This is a statute that is a very important tool, and commonly I see local governments that don't make use of it, but I think it's really one of, if not your best resources for dealing with unfit property. This statute allows the local government to adopt an unfit property ordinance. And it defines unfit properties as properties that are not fit for human habitation or for commercial, industrial, or business occupancy. Now, a lot of times people think this means that the property is so bad that it just needs to be torn down. That's not right. And I'll talk about that some. First, when you adopt this ordinance, it needs to state in there that you have a problem with unfit properties that are causing blight. And it needs to identify a public officer who's going to be in charge of enforcing the ordinance. So it's probably going to be your code enforcement officer, but it could be your zoning administrator, it could be your building official. It's not, it's up to the local jurisdiction. It provides that when this person identifies a unfit property, then they have to perform a title search, find out who all has a legal interest in the property, and then they'll give notice to all those people. They'll file a citation or an unfit property action and give notice to everyone who has any interest. So when I say who has any interest, obviously the property owner, but that may also include the tenant, a tenant that's staying there. That would include a bank that has a security interest in the property, if there's a loan on the property. Sometimes, lately, what I've seen is people who have purchased a tax deed on the property. That's where if someone hasn't paid the taxes on their property, the tax commissioner may sell a tax deed. An investor comes in, pays off the amount of taxes that are due, and then they get an interest in that property. And if what they paid off or paid on those taxes is not paid off by the property owner or redeemed, then ultimately they get an interest in the property. You'd have to give that person notice. unfit means. It doesn't mean that the house needs to be destroyed or taken down. It means that it's got problems that need to be fixed. So it can be something that is as bad as the house needs to be demolished, but also could mean that the house just needs to be repaired. It needs to be brought back into compliance. You can deal with defects increasing the chance of fire, lack of adequate ventilation, dilapidation, disrepair, structural defects, and uncleanliness. So here's an example. You've got septic tanks that are failing. That's something that you can fix with this. If you've got vegetation that is overgrown to the extent that it's made the property unsafe, that can be fixed through an unfit property action. So once the officer has determined who all has an interest in the property, then he's going to file a complaint in your municipal court. And that complaint is going to, he's going to set a hearing date, and all that information is going to go to the property owner, the tenant, and anybody else who has any legal interest in the property. And it's going to actually be tacked up on the building itself. Why is that? This is called an in rem action, which is a legal term that means it is a lawsuit against the property. That's really important. You serve property owners and all these people via certified mail. Those of you who have much legal experience will know that normally, under the law, if you want to serve someone with a lawsuit, you have to hand it to them individually. In fact, normally you have to have a sheriff's deputy or a process server serve them personally with the document, literally hand it to them. In this case, under this statute, you can mail it to them by certified mail. So that makes it much easier, particularly if the person or the person holding the interest is a bank located out of state. That makes it much easier on the local government. It's in rem because it's against the property, and you tack the notice on the property itself. Then, at this hearing, if you can show that the property needs to be repaired or demolished, and the judge finds that that should be done, he will order that those repairs or demolition be accomplished within a certain set period of time. And if it's not done, this is the key point, the local government is authorized to do it itself. And whatever the costs are in doing it can then be placed as a lien against the property. So suppose you've got a house that's, it's a complete and utter wreck, it's unfit for habitation, and the court says this house needs to be torn down. If the property owner doesn't tear it down within that period, then under this statute, the local government would be authorized to send contractors in, tear the house down, get it back into a safe condition, and then place a lien on the property. Now, that lien is collected just like taxes, so it may be that you'll get the money back that way, or it may be that the property, once it's cleaned up, will be sold. A lot of times, if you've got a dilapidated house on the property, it's worth more once you've cleaned it up than it is beforehand. So the property gets sold. In order for that property buyer to get clean title, at closing, the city's lien is going to have to be paid off. So the city stands a good chance of getting paid back. Now, that does not mean that there's a no cost to this process. I don't think a city can go into this with the idea that every dollar that it spends is going to be paid back. Some properties aren't worth a whole lot. It may be that even after you clean it up, the property is not worth what it costs to clean it up. So it can still be an expense to the city. And I would say, you don't want to go down this path unless your city is committed to spending the money it takes to clean it up. And just hopefully you can defray some or most of those costs. Another thing, and I've seen this before, if your city does not intend to actually fix the property itself, if it comes to it, there's no reason to use this process, because the only jurisdiction you're getting over the property owner is just a certified mail jurisdiction, if there's no fines that are going to be imposed on him, the order require him to clean it up. The only remedy for him not doing it is now the city can clean it up. So if the city doesn't intend to clean it up itself, if the owner fails, then you probably wasted your time, and you need to find a different enforcement mechanism. In that situation, if the city is not going to be willing ultimately to clean it up, if it has to, probably better off going with citations or maybe filing an action in the Superior Court asking for an injunction. So that's why I say there are a variety of remedies, and you have to figure out which is going to be the right remedy for your particular situation. This tool is a really useful tool in situations that I have seen commonly where you have someone who has passed away and the home is now owned by an estate and none of the heirs want to deal with it. You can't make them come in and take this property and fix it. Well, this mechanism says you give them an opportunity to fix it, but if they don't, ultimately the city's going to do it and put the cost of the repair on the property itself.
Brandon,
Yes.
we got a few questions that have come in. If you got a moment, I'd like to just kind of pose them one at a time.
Sure.
The first one is, how is uncleanliness defined?
That's a good question. I don't know that it is specifically defined. The key thing is that it would have to be a level of uncleanliness that is so bad it has rendered the property not fit for habitation.
Oh.
So, if you've got a situation where somebody hasn't hit their house recently and it's looking kind of bad, that may be a violation of something, but it's probably not going to be a violation of the unfit property statute. On the other hand, if they don't have working septic systems, and so that's failing, and they're not properly disposing of their waste, or I've seen situations where people have 10 dogs in their house, and those dogs are not being maintained or controlled in such fashion that they've made it not safe for human habitation. That is a level of uncleanliness that would be bad enough to make the house uninhabitable, potentially.
Okay. A couple of other questions. One is, on civil citations, is there anything that can be done if they do not show up to court?
If they don't show up to court, what do you do? Okay. Well, in the unfit property or in the unfit housing context, if you've given them notice of the day of the hearing and they don't show up, I think you can go forward with the case if the judge is willing to do so. The judge may say he doesn't want to, but I think he'd be perfectly authorized to do that. On other violations, citations, for instance, say someone is cited for having a junk car, in that case, the judge is probably not going to go forward because that is essentially a criminal prosecution. He's probably not going to want to go forward on the citation. However, he will probably issue a failure to appear bench warrant, and then that person may be arrested if they don't appear. So the municipal court has the means to get people there or make them wish they had come voluntarily. I think that's the key point.
Okay. And another question, and then we'll move on. What ways can you serve citations when using property maintenance code or nuisance code?
All right, so if you're using a property maintenance code, you want to serve someone. Generally, the best way to serve is going to be to hand in that citation, because under most situations, that's how you get jurisdiction to bring the person to court, is that the officer has handed them that citation. Now, if you mail them the citation and they come to court and they don't raise the issue, then no harm, no foul. You'll eventually get somebody who says, I was not properly served, and the judge can say, well, how'd you serve them?
Thank you.
All right. Bill, were there other questions?
Brendan, there are a couple more that kind of we might catch those at the end to kind of go back further back in your presentation, but we'll catch those at the end so you can go ahead and move forward.
Okay. There's one other big issue I want to cover, and that is the Foreclosure and Vacant Property Registry. There's a new statute. I say it's new. It's a couple years old now, but it was adopted as a result of the recession and the foreclosures that occurred as a result of it. Many code enforcement offices have complained that they have properties where that they are not being maintained, and the property owner either says, I've been foreclosed on, or there is a bank that has foreclosed on it, or maybe an investor has purchased it. But the problem that the property owner or the code enforcement officer has is they can't find a live person to talk to try to get this problem resolved. So what the Foreclosure Registry statute says, and let me back up, some jurisdictions devise a fix themselves by requiring banks that foreclose to notify them of the foreclosure and provide all kinds of information and pay not fines but fees to maintain this registry. Well, that caused a big stir, and so the legislature adopted this statute that says you can have a foreclosure registry, but if you do so, you have to track this statute exactly. You can't deviate from it. So let's talk about what this statute says. Okay. It talks about property, it applies to foreclosures and vacant property. And whenever you hear vacant, that scares people, but it's got a fairly narrow definition of vacant property. Vacant property under this statute is property that is intended for habitation but has not been inhabited for 60 days, has no evidence of utility usage, and is not actively being marketed for sale or rent. Commonly, when we adopt this foreclosure registry, landlords will come forward and say, hold on, is this going to apply to me? I've got a property where the tenant has moved out and I don't have anybody in there yet. That's probably not going to apply to a landlord who is just having turnover in his house or his property. One, it's got to be 60 days of vacancy, no evidence of utility usage. Most landlords are going to keep the power on so they can maintain the property until a new tenant comes in, and is not actively being marketed for sale or rent. Your landlord who has a vacancy is going to be marketing that property for a new tenant, so it's probably not going to apply to them. It does apply to properties that have been partially constructed but no longer have a valid building permit. Saw a lot of that in 2008 where people got started, where builders got started on homes, and then with the recession, they went belly up and no one is actively working on that building anymore. It also deals with properties that are held as a result of foreclosure. It excludes multifamily structures where any one unit is being inhabited. So if I've got an apartment building and some of the units are vacant and some of the units have tenants, this statute does not apply to that property. I don't have to worry about that. So suppose a bank forecloses, and the common procedure is, I think it's helpful to talk about how a foreclosure works because most of us who don't deal with it don't necessarily understand this. When somebody gets a loan for their house, they file or they sign a security deed, which gives the bank the right to foreclose if they don't pay their mortgage payments monthly. So say the property owner doesn't pay it and the bank forecloses, all they have to do is send a notice to the property owner that they're going to foreclose, and they have to run an ad in the paper once a week for the 4 weeks prior to the foreclosure sale. Foreclosure sale is going to occur on your first Tuesday on your courthouse steps. So it's not a very long process. Basically, in 5 or 6 weeks from determining that they want to foreclose, the bank can foreclose. That's how long it takes them to go through the process. The problem I have seen repeatedly from a code enforcement standpoint is that the bank will send a foreclosure notice, I presume thinking that if they'll send the notice, the property owner will get in touch with them and will catch up the payments and they'll be all right. because the banks don't want to foreclose generally. They don't want to own property. They'd rather get paid. So they send this notice without actually intending to foreclose, and they don't foreclose. But nevertheless, property owner gets a foreclosure notice. Maybe they can't pay the payments. So they think, well, I've lost my house. They may move or they may not move. They don't think it's their house anymore, regardless of whether or not the foreclosure, whether or not the bank actually foreclosed. That's a big problem for the code enforcement officer. And, key thing that matters is until that foreclosure actually occurs, until the sale actually happens, that property owner who's living there, they still are required, they still own the property, they're still required to maintain the property. So once that Tuesday comes and the bank actually does sell the property, then probably in more than half of the times, the bank actually buys the property back for the amount of the loan or some other amount, some lesser amount that their appraiser says the property's worth. So the bank then sells the property to itself, essentially. Sometimes an investor buys it. Sometimes somebody who wants to live in the house themselves buys it. In either case, that will result in a deed, a foreclosure deed. Now, these foreclosure deeds, they'll have the property owner, the name of the bank that's selling it on their behalf, and whoever buys it, listed by name. But that's about it. And that deed is not necessarily very helpful to a code enforcement officer because it does not identify anybody who would actually be responsible for maintaining the property. So, what the foreclosure registry does, where it comes in, is it requires that foreclosing bank to notify, or actually the person buying it, to notify the city of new owner's name, address, phone, fax, email address, and also a local agent's name, address, phone, fax, email, property address, transfer date, and the deed and book information. You can require that transferee, the person who's buying the foreclosure, to give you that information so that now your code enforcement officer knows who to contact to get compliance.
Brandon.
Yes.
A question has come in. Do you recommend a boarding permit for vacant structures?
A permit to actually board up property?
I believe that's what the question refers to, yes.
I have seen that before. I think there are two key issues. One, in other cases where I've seen this, the ordinance had some other provisions in it that did not comply with this foreclosure registry, which could potentially render it invalid. So I would be careful about that. The other is, I don't really understand the purpose of requiring a permit before someone boards up the property. What I prefer to see is an ordinance that requires the property owner to maintain the property, and if it's vacant, require them to secure all the points of access in a satisfactory manner. Then you don't have to get a permit for them to do it. You just can tell them, hey, you need to do this, board it up. And if they don't, then you can issue a citation to them under that ordinance. I think that's probably a better way to do it. I guess you could require them to get a permit first. I don't know why. I don't really know what purpose the permit serves, other than I guess that gives you the opportunity to look at the mechanism they're going to use to secure it beforehand. I guess that's a judgment call.
Okay. And a suggestion's been made if there are any of the agencies out there that currently have a registry requirement ordinance, they might want to share that. And in a follow-up email to all the participants, we'll ask you to share that with us. So we just wanted to make that comment.
I believe GMA has a model foreclosure registry ordinance.
Yeah.
So that may be helpful to you. If not, if anybody has any questions, I've drafted several. I'd be happy to share with you what I have as well. Okay, so if you adopt it under the statute, you have to give the new owner 90 days to file the registration. It also says if they file the deed with the clerk of the Superior Court within 60 days and it contains all that information and they give that to the county, then you can't charge them a fee. Otherwise, you can charge a fee of no more than $100. and an penalty of no more than $1,000 for failing to register. So they can avoid the fees if they just put all this information on the deed. Deeds don't have that information on it. I have not seen a single case yet where a lawyer, a closing attorney, changed the deed to put all that information on there. So I don't think that's going to happen, but who knows. Key point, this statute is not self-effectuating. What that means is you can't just go you can't just have your staff start keeping a foreclosure registry. You actually do have to go through the process of adopting an ordinance to do that. And you also have to have administrative procedures, similar to the procedures we talked about earlier on today about having an officer who's in charge of maintaining it and an appeal process. I'm not sure what kind of appeal anyone will ever file, but the statute says you have to have that. I'll tell you what, I left this on here, this slide, but I think I'm going to skip it because it's really a little bit further outside the scope of what we've been talking about today. But Bill, I believe you said there were some other questions. Okay. If not, I appreciate the opportunity to speak with you today, and feel free, if anybody has any other questions they think of later on, feel free to give me a call. I'm going to send this presentation to Bill, so they'll have it there, and I hope everyone has a good afternoon. Thank you.
Thank you so much, and this session has been recorded. We'll make it available as well. Thanks again, Brandon, and for all of you for joining today's webinar.
You're very welcome.